Good morning. In this video I want to take a look at the employment law issues arising from the coronavirus COVID-19 disaster. Obviously all of us are feeling the pinch and are going to feel the pinch, and it's difficult to know when the thing will be resolved. All we can do at the moment is listen to the best medical advice from the HSE and the public health experts working for and with the HSE. In this video, however, I'm going to look at the employment law issues arising from the coronavirus, and I know this is causing a great degree of concern for a great many people. So let's take a look. Firstly, I'm going to take a look at 7 scenarios, 7 situations that I've written about on my website employmentrightsireland.com. This is 7 possible situations which may arise, and I'm hoping to give some clarity. First one is where the employee contracts COVID-19. So the employee must go into self-isolation, and the employee's sick pay entitlements, if any, will be those set out in the contract of employment and our staff handbook. This will vary from job to job. It will vary from industry to industry. For example, some professionals, some people, some public servants, for example, teachers, HSE employees and so forth, will have a sick pay scheme, some sort of a sick pay scheme, which may last for 6 months or 12 months or 3 months or whatever. Generally it involves full pay for a while and half pay for a while. That's in a very lucky scenario or fortunate scenario for those employees. Most private sector employees, however, will not be entitled to sick pay. There will be no sick pay scheme in the work, in the job, but if there is, it will be set out in the contract or the staff handbook. There's generally no legal or statutory entitlement or obligation on the employer to pay sick pay. The employee may be entitled to illness benefit from the Department of Employment Affairs and Social Protection, and the illness benefit situation has been changed, has been improved fairly significantly in the last couple of weeks. Second scenario I want to look at is employer closes, the employee can work from home. Well, then the employee works, he's entitled to be paid. It's as simple as that. So he's working from home, the employer has closed the workplace. It's the sort of a job that can be done from home. For example, I could do quite a bit from home. However, if I was working in retail or someplace like that, or cleaning or some sort of a service industry of that nature, well then clearly I can't work from home, I must go out. That's a problem. But generally the employee is working, well then he or she is entitled to be paid. The third scenario I want to look at is the employer closes the workplace, the employee cannot work from home. The employee, unfortunately, is not entitled to be paid. Now, annual leave may be a situation, may be possible to exhaust. In other words, if there's untaken annual leave, it may be possible to, on a temporary basis anyway, to use up the annual leave untaken and accrued annual leave. Parental leave may also be an opportunity, or maybe a possibility. Unpaid leave may be a possibility, but the options are not great. The fourth situation is the employee cannot come to work because she is caring for a person who has COVID-19. Force majeure leave may apply, but there's no guarantee of this. The maximum amount of force majeure leave in any event is 3 days in a 12-month period, and the care must be of a close family member with the employee's presence indispensable in the circumstance. So that may or may not be the case. Force majeure is defined in the legislation and it's defined quite tightly. We'll have a look at that later on in this video, but it's unlikely, quite frankly, that force majeure will apply, although the employer could accept that it's a force majeure situation without getting too pernickety or too legalistic about it. The fifth situation is there's no public transport and the employee cannot get to work. The employee, from a legal perspective, is not entitled to be paid. 6, the school closes and the employee must stay at home to mind children, has child minding difficulties. The employee can continue working at home, well then obviously entitled to be paid. Employee cannot work from home, not entitled to be paid. And annual leave, parental leave, unpaid leave may be possibilities, may not, depends on the circumstances. But bottom line is, if the workplace is open and there's work available, well then generally the employment contract obliges the employee to show up and work. If the employee returns from an infected area and is told to self-isolate, there's no entitlement to pay unless he or she can work from home. If he can, well and good, he's or she is entitled to be paid. There's new illness benefit measures, or new measures there in relation to illness benefit, which have only come into being since the coronavirus crisis has hit. There's a 6-day waiting period, or there was a 6-day waiting period for assessment for illness benefit. That no longer applies. The benefit has increased to €305 per week for a maximum of 2 weeks for anyone in medically required self-isolation or for the full absence from work on account of a diagnosis of COVID-19. The normal social insurance requirements for illness benefit will be changed, or the means test for supplementary welfare allowance will be removed. But you need to check on the Department of Employment Affairs and Social Protection website. There's plenty of information out there from the various government departments to do with illness benefit. Layoff and short time are situations that are going to be more commonplace, particularly now that there is a significant campaign online, I see this morning on Twitter, to close the pubs, for example, because there's been quite a bit of criticism of pubs and hotels, but particularly pubs where people are going out and are apparently not engaging in social distancing or physical distancing, which is required. So it is a possibility, I suppose, that pubs will close or hotels will close. If that's the case, you're looking at a layoff or short time situation perhaps. Layoff is defined in the redundancy payments legislation, and it happens when the employer is temporarily unable to provide work for the employee. Short time is the situation where the employer cuts the wages or cuts the hours of the employee to less than 50% of the normal hours or pay. So what is the situation in relation to layoff and pay? At common law, the employer is not entitled to lay off without pay unless, 1, there's a clause in the contract allowing the layoff, or 2, there is an implied right to do so. The implied right would derive from custom and practice in the industry or in the particular employer's business. So there may be some precedent there. By and large, though, the employer is not entitled to lay off without pay. That is the common law position. However, there is decided cases from the WRC, and prior to that from the Rights Commissioner, and prior to that from the EAT, and indeed from the Labour Court. And essentially they have held the decisions are authority for the proposition that there is an established practice in Ireland that layoff without pay can be permitted where it can be shown that it is custom and practice in the industry or trade. Alternatives to layoff or short time would include annual leave, unpaid or untaken rather, and accrued annual leave, parental leave or unpaid leave. A redundancy entitlement may arise in a situation of layoff if the employee has been laid off or on short time for 4 or more consecutive weeks, or for 6 weeks in a 13-week period. The employee can serve a notice on the employer claiming an entitlement to redundancy. The employer, however, can dispute this and can serve a counter notice denying the redundancy if he can give the employee 13 weeks' work without layoff or short time. This work must be available within 4 weeks of the employee's notice. So the employee serves the notice and says, I'm entitled to redundancy, and the employer essentially says, no, it's a very temporary nature, and now I can give you work. Here's the notice, and I can give you 13 weeks' work without layoff or short time. The question of force majeure then is something that might just arise in relation to COVID-19. The argument might be made, but I don't think there's a huge amount in it. However, force majeure is defined generally as a superior force, and it's afforded statutory protection in Irish law in the Parental Leave Act in 1998. So an employee shall be entitled to leave with pay from his or her employment. This is force majeure leave, where for urgent family reasons owing to an injury to or the illness of a person specified in subsection 2, the immediate presence of the employee at the place where the person is indispensable. This would cover, for example, a situation where a parent may be critically ill and may be on the way out, quite frankly. In that situation, then there may be a force majeure leave situation arising. Also where there might be a road traffic accident and somebody has been brought to hospital or something of that nature. But the definition is fairly narrow, and a lot of employees don't actually understand that and think that force majeure will cover a whole lot of types of leave. It won't really. Now, it is possible to put a force majeure clause in an employment contract, and some executive type contracts of employment may contain such a force majeure clause. And most employment contracts will obviously refer to the statutory relief provided for force majeure in the Parental Leave Act. A force majeure clause in a contract will usually have the effect of suspending the obligations of one or both parties in certain exceptional circumstances. That is to say, events like storms or earthquakes or other acts described as acts of God may qualify as force majeure events as envisaged by the contract. There's no presumption in Irish law of a force majeure event, however, so the parties need to specify what events are intended to be covered by the force majeure clause. This, I have to emphasise, relates to a contract of employment and a specific provision in it, a specific clause dealing with force majeure. But without this clarity, without specifying what events are to be covered, then the clause may be unenforceable on the grounds that it is void due to the uncertainty and lack of clarity around it. Is COVID-19, the coronavirus, then a force majeure event? It's worth noting that the phrase force majeure has no recognised or widely accepted meaning or definition in English law. The question, therefore, of whether COVID-19 is a force majeure event is a question that will almost certainly be determined by the particular circumstances of the contract and what was envisaged, what type of work was involved, whether the performance of the contract was genuinely prevented by the coronavirus, and so forth. The force majeure event, again in relation to the employment contract, should be defined in the force majeure clause. For example, it might say it means an event or a series of related events that is outside the reasonable control of the party affected, including power failures, industrial disputes affecting any third party, changes to the law, disasters, explosions, fires, floods, riots, terrorist acts and wars. These are obviously force majeure events, but a court will interpret the clause strictly and narrowly. Notices then, each party would normally be obliged to serve some notice on the other party and inform the other party as soon as possible of the difficulty or impossibility of performing the contract and suspending it for a time. A contract of employment may benefit both the employer and employee by the inclusion of a force majeure clause. However, it's not a silver bullet solution to the COVID-19 problem facing both employers and employees in Ireland. I am trying to provide or roll with the punches in terms of the coronavirus, and I'm certainly following the best practice, the best advice, the best medical advice. I'm trying to engage in social or physical distancing in order to prevent any spread of the virus, so I'm offering consultations by phone, by email, by video. Now, I will do an in-person one where it's necessary, and it is necessary in some situations where, for example, somebody needs to sign an affidavit or where somebody needs to sign a contract for the sale or purchase of a house. That's no difficulty, but by and large we are doing consultations or trying to get the consultations by phone, email, video. Consultation with me costs €100, and there's more details on my website businessandlegal.ie or employmentrightsireland.com. But I'm a solicitor in Enfield. I hope you find this video useful. If you do, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel, and I would ask you to share the video and with anyone who you think might benefit from it. But most of all, I would encourage you to please follow the legal or follow the medical advice from the doctors and do what they tell you in terms of trying to prevent the spread of the coronavirus. And hopefully within a matter of months, or certainly within perhaps even a matter of weeks, we'll all have this behind us and we'll all be trading war stories about what it was like during the coronavirus crisis. But for now, we all have a part to play, we all have a small role to play, and that involves washing our hands, practicing good hygiene, and engaging in practicing social exclusion, or social distancing rather, physical distancing. And when I say physical distancing, I mean staying away from somebody else if you can do that. And obviously social distancing isn't so important because you can actually maintain a social proximity with somebody through email or through phone or through video or through Skype or whatever. So I think the physical distancing is more important. As I say, I hope you find this video useful. If you do, you might give it a thumbs up down below. Thanks for your time.